This is Why Small Business Matters from Northumbria University, supporting small businesses with the Help to Grow management programme.
Hello and welcome back to Why Small Business Matters. My name is Sarah Stephenson, and in today's episode we discuss intellectual property and patents and why small business needs to think about legal protection of inventions, creative works, designs or software. And protecting your assets can be very important. Legal rights like copyright, trademarks, patents can stop other companies from copying or stealing your products or services. So today I'm delighted to be joined by two experts in the field of intellectual property, chartered and European patent attorneys Charlotte Watkins and Jason Boakes, who founded the patent law firm Secerna in 2011. And based initially in York, Secerna now has offices in Newcastle and Dublin, providing an integrated service focused on the protection, enforcement and defence of intellectual property. So welcome, Charlotte and Jason.
Hi.
Hi.
Now, before we explore what intellectual property is, I'd like to understand really about you and what a patent attorney is and why you set up the business.
My name is Jason Boakes, and I founded the law firm Secerna with Charlotte in 2011. We were previously involved in other firms, and we decided we wanted to create a firm that was quite client-driven and that would offer truly expert services in an environment where everyone felt supported. And we predominantly offer patent, trademark and design services to our clients. The role that we have is very varied. We represent the creators of intellectual property. That is to say, we represent the individuals that invent new inventions or create new artistic works or who wish to brand a new name or logo for their business. And we also help enforce the registered and non-registered rights that protect the intellectual property of our clients. We also act on the opposite side of matters. So one part of our business is about protecting the intellectual property of our clients, but we also represent the interests of clients who are concerned about the intellectual property rights of other parties. So we also assist clients who are concerned with patents owned by others. We help them understand the intellectual property landscape and try and mitigate the risk in their business.
So Charlotte, maybe you can tell us a little bit about where you have come to Secerna from, but also then go on to talk about what intellectual property is, because I'm not sure everybody really understands what that means for a business.
So I was previously at the same large firm, and we worked with sort of innovative companies then, and we thought, well, it'll be great to start our own business, and I think it's really helped to understand what SMEs go through right at the start, and the different challenges that you face as a business matures. So we're obviously in the field of intellectual property, and there's a number of different rights that encompasses. That can be registered rights and unregistered rights. So we work with patents, and that is a form of registered right that helps to protect how something works. So you can protect some goods, some products, or a particular type of method or process. So in the Northeast, we have a lot of innovative companies working in, for example, renewable technologies. So they will be inventing matters to do with wind turbines and things like that. Another form of registered right is a registered design, and that protects how something looks. And so a lot of the products you'll see on the high street and in every day-to-day use will have a registered design on it, like the Dyson vacuum cleaner will have lots of registered designs associated with it. The Crocs shoe that everyone is wearing on the beach this summer will have a registered design. And so that can be very helpful in protecting if you're associated with fast-moving consumer goods, for example. If you have branded products, often you will want to protect the name that you associate your products with by a trademark. And trademarks can be anything from a word, a logo, even a smell. So I think originally the Slazenger did a trademark for the smell of freshly cut grass associated with tennis balls. The Coca-Cola bottle was originally a trademark. So there's a number of different registered rights that people can create as part of their business. And it's important to understand what might apply to what your business is doing. There's also unregistered rights that can often be created automatically, like copyright. So if you have databases of sales contacts and things like that, that might well have a form of copyright associated with it. So the word IP covers a lot of different forms of property, and it's important to understand right from the start what you might be creating and how best to protect it.
Secerna calls itself a patent attorney firm. So it sounds very American, doesn't it, patent attorney? But you're lawyers who deal in intellectual property. So where did the word attorney come from? Why? Because that might be confusing for some businesses.
Well, I think the word attorney came from America, probably. Historically, the patent attorney profession in the UK tended to be referred to as patent agents, and the professional body that looks after the patent profession used to be called the Chartered Institute of Patent Agents. But in America, the patent agent term means something slightly different, and it was leading to some confusion. And so the UK profession has aligned itself more with other countries around the world. It's the patent system is involved in multi-jurisdictional issues. Inventions tend to be protected in multiple countries, and so it's quite useful to try and align some of the terminology with different countries around the world.
So I think it's important to note that we aren't solicitors, so we don't have a law degree. We all have to have a scientific or technical degree before we enter the profession. And we undertake our own set of patent attorney exams in order to qualify as a patent attorney. So we are lawyers, but not solicitors.
Tell me a little bit about intellectual property as a notion for business. Obviously, it's valuable, but businesses who may think they have something to protect, why is it important to make sure they do it properly and come to a patent attorney or really understand what the value is to their business?
So I think it's important to note that I think IP can often make up a substantial portion of a business's value, particularly businesses involved in technological sectors such as healthcare, IT, engineering. For some companies, the value of their entire business, 50% or more, can be attributed to the IP they own. So I think that's really key to understand. It is a business asset. It forms a great portion of just the value of your business, but also it can be used as a tool going forwards in terms of trying to raise funding. It has some maybe indirect, it indirectly contributes to the value of a business. For example, the UK Intellectual Property Office published some statistics quite recently, which said that there was 20% higher revenue per employee for a company that registered their IP, and up to 10 times higher likelihood of access to early stage finance than those companies who didn't have registered IP. So I think those kind of statistics really bring home how important IP can be to an SME.
I think, you know, one of the issues it's maybe helpful to add on that is the term intellectual property is not just some vague term that's been selected. It is a meaningful phrase. Intellectual property is property. People are accustomed to understanding what's referred to as tangible property, houses, cars, factories. Intellectual property is no different in the sense of one can deal with that property just as you can deal with tangible goods. You can sell it, you can assign it, you can use it to support mortgage payments. And it should be thought of as a mechanism to protect your property in the intellectual property space rather than in the tangible real world space. It provides exclusivity, just like if you purchase a house, you have the right to live in that house and exclude others from spending time in that physical space. Intellectual property gives you the right to exclusivity in the intangible intellectual property space. And that exclusivity lasts for different periods of time. For patents, for example, your right to exclude others from that technological space tends to last around 20 years. And then everyone is free to move into that space and share that space, effectively using what other people have taught them to do. Other rights, such as copyright, lasts a different period, depending upon the nature. It might be between 25 and 125 years from a certain event happening. Registered trademarks can last much longer, depending upon whether you make payments. So the phrase intellectual property is just a way of categorizing a different property. It's saying it's intellectual property. It's not tangible property like a house or car.
That's a really great way of trying to understand what it is, actually, thinking of it as like a tangible part of your business. Presumably then you mentioned, you know, going out for mortgage payments or attracting investors, that sort of thing. So can you use that as part of your research and development? Can you use it for tax relief? How would that work for a business?
Yeah, absolutely. The tax relief, there's two real systems in place for tax benefit. They're both really linked to the patent right as opposed to other intellectual property rights. There's something called patent box in the UK, and there's something called R&D tax credits. Most SME businesses will have firms of accountants or advisors like Secerna that can help them sort of dissect the details between patent box and R&D tax credits. Broadly speaking, though, if one secures a patent for a product or service and a company makes profit and pays corporation tax, instead of what is typical in the UK at the moment between 19 and 25% tax, you can reduce that tax burden on your profit down to 10%. So there can be a very significant saving. Equally, R&D tax credits, they are associated with businesses that have spent money on research and development. There are two types of credits, one for SMEs, small, medium-sized enterprises, one for larger. But for SMEs, you can, in certain cases, reclaim up to 33% of what you've spent on R&D related issues. So there is significant opportunity there for SMEs, and they should talk to some experts, patent attorneys or accountants about those tax related incentives.
That's really helpful. And I just want to return to businesses and why they might come to a patent attorney firm like yours. I mean, presumably there are mistakes that businesses might make, whether that's through premature disclosure of their ideas or something like that. And just wondering whether you could talk us through why it makes sense to come and talk to experts to begin with.
So I think there are a number of mistakes, especially when SMEs are at the start of their journey. They're obviously very cost conscious, and so I think one of the key things we see is a premature disclosure of their IP. And with many forms of IP, it's really important that it shouldn't be disclosed before you register it. And the disclosure can take the form of, well, they've gone to talk to somebody without a non-disclosure agreement in place, for example, or they've presented at a conference. And then often, not always, but often that means that their opportunity to register that IP is lost. And there are certain things that we can then advise to try and regain some protection. I think also at the outset, often SMEs can get involved in collaborations with third parties, and perhaps the agreements aren't in place or are in place but not covering IP fully and correctly, and so they can lose out on ownership of IP through not having secure contracts, including employment contracts or consultancy agreements in place. So those are often the two kind of scenarios that we often have to advise on. And also, I think what we try to do is, from the outset, if we are talking to an SME that maybe hasn't protected IP yet or has just started along that process, it's about getting an IP strategy in place. You know, businesses often start up with a business plan, and it's just as important, if they are in the world of generating IP, to get a strategy in place right from the start. And that means that you can start to control the costs, you can have a clear vision of where you want to go, and you can start to protect the core assets of your business. Sometimes it's very easy for a business to say, well, we've invented this and we've invented this, try to protect it all, but actually they're not core to the business. And so money can be wasted pursuing maybe non-core IP. So that's what we would often advise right from the start is, right, let's sit down, see what you have, see what you may produce in the future, and from that, get an IP strategy in place.
It's maybe helpful to sort of explain that there isn't a one-size-fits-all approach for any situation, really. There are lots of hybrid approaches that one can take for businesses, dependent really upon the situation that they find themselves in. It is quite important for decision makers in SME businesses to have at least a reasonably basic understanding of the various rights and various issues that they need to think about. And you know, most firms of patent attorneys like Secerna would meet some decision makers early on for an initial consultation and explain those basics. But in some circumstances, it is important not to dabble, because in some situations you can make your situation far worse by trying to deal with some things yourself. And it makes it much more difficult for patent attorneys like Charlotte and I to unpick a situation that an SME finds itself in.
So I think the message coming across loud and clear is, come and talk to us first. Let's understand your business, and then we can help you with whatever IP protection might be relevant to you.
I think that's right. And, you know, we would tend to see a graded or gradual approach. You know, for most SMEs, they're frankly just concerned about getting out of the ground. You know, they've only got a limit to the money that they have available, so they have to make tough decisions about what they do with that money. But we can always do something and doing something right at the outset can really save a lot of heartache down the line. And then as the enterprise grows and has more access to money, then we would, using the strategy we've developed, we would then evolve what the business concerns itself with, how much protection, how much it looks at third-party competitor rights to limit the risk to the growth of that business.
I think you've touched there on probably what SMEs talk about really, which is protecting IP can sometimes seem really expensive. You know, they're perhaps nervous about coming to a patent attorney firm. You talked about strategies. So is that the most cost-effective way of doing it, coming to talk to you initially, finding out what rights they may already have?
I think, protecting and defending IP can be expensive, but I think the cost has to be considered in the context of what it adds to the business. And as Jason said, it doesn't have to be right. We must protect everything all at once. It can be graded. It can be put into a budget going forwards. And certain actions can be taken at certain times. And so I think it is something that, as I say, can be perceived to be very expensive, but ultimately it needs to be protected in order for you to maintain a market position, for you to be able to stop other people copying you. There are cost-saving measures. There are some various government-supported schemes that might be able to provide you with grants that help you generate an IP audit of what you have. So there's some good governmental schemes that get announced every year. Those can help you set out what you have, and on that you can then put your strategy together. You can complete your own searches prior to filing any intellectual property, so that if somebody's already done what you think you've invented, then there's no point proceeding potentially. So there are cost-saving measures, but I think ultimately it's about focusing on what is the most important part, what is the most important thing to the business, is one of the ways that you can at least minimise the cost.
And in terms of the cost, again, something to reiterate is patent attorneys, we live in the real world. We understand that SMEs have a limit to what they can spend, and they need to make tough decisions. So it is important to understand that we can adopt some sort of hybrid approach. We can try and get some easy wins for a relatively modest cost, particularly in the patent sphere, though. Unfortunately, it is a truism that you kind of get what you pay for. A patent is not a commoditized product. It is really a contract, and it needs to be created professionally. So that is one aspect, one intellectual property right that really needs to be dealt with properly early on. But other rights, we can secure protection for, registered trademark protection, etc., for a much more modest cost. And what we would tend to do is understand what is feasible in context, and then develop maybe a timeline for when certain things can be protected.
You're listening to Why Small Business Matters. Find out how Northumbria University can help your business thrive through the Help to Grow management program, delivered by leading small business and enterprise experts from Northumbria University, with the support of leading figures from industry and experienced entrepreneurs. The program supports senior managers of small and medium-sized businesses to boost their business's performance, resilience, and long-term growth. The 12-week program is 90% funded by the government, and the fee payable by participants is £750, and has been designed to allow participants to complete it alongside full-time work. The in-depth, high-quality curriculum supports you to build your capabilities in leadership, innovation, digital adoption, employee engagement, marketing, responsible business, and financial management. By the end of the program, you'll develop a business growth plan to help you lead your business to realize its potential. To find out more about the program, the modules, eligibility, and fees and delivery dates, go to northumbria.ac.uk/help-to-grow.
You're listening to Why Small Business Matters. I'm Sarah Stephenson, and today we're talking about all things intellectual property with Charlotte Watkins and Jason Boakes from Secerna. We've talked about coming and thinking about what our intellectual property is and how you might be able to help protect it. But what do you think if a business comes to you and they think their IP has been infringed? How can you help support them either to find out what's going on or help them defend that?
So again, I think it might depend on the type of IP that they own, and there are various different actions you can take depending on that IP. If they think they're being infringed on, say, online marketplaces, there's various things that you can achieve using things like takedown notices, and some of these online platforms are very good at recognising registered IP and will act accordingly. But again, care has to be taken and advice has to be taken not to do it yourself, because there's some pitfalls if you do it yourself, and you can be considered to threaten that infringer. And then there's other approaches you can take. You can try to negotiate settlement agreements and license agreements with somebody you think might be infringing your IP. And from that, you might be able to generate some revenue. If you think, actually, this competitor really could destroy my marketplace, then you can try to achieve preliminary injunctions to stop them selling. So there's a number of different ways you can approach a potential infringer. It will often just come down to what your situation is, what the IP is that you think you have, the strength of that IP. And that's all, again, something which we would sit down and discuss as a whole before coming up with a proposed approach with that client.
It's maybe useful to point out that the IP system is usually seen as two sides of the coin. One is a potential threat to your business, and one is a potential opportunity to your business. So for many of our clients, we represent the businesses that own the intellectual property rights, that have either got unregistered rights or have secured registered rights. And those rights enable our clients in those situations to exclude or stop others doing what they don't want them to do. But there is a converse issue, which is where other businesses have intellectual property rights, such as patents or registered trademarks, and they want to stop our clients. So firms like Secerna will represent clients on both sides of those positions, depending on who the client is. Sometimes we find ourselves defending a client, and sometimes we find ourselves behaving on behalf of the client to enforce their rights. And in those two different scenarios, there are very different steps that we can take. If we represent a client who owns the, for example, patents or registered trademarks, we might send some communications to a competitor firm, notifying them of the rights and asking the competition to stop doing what they seem to be doing. And in many instances that does work, and businesses, business leaders and decision makers don't like uncertainty and don't like risk. And so often the situation is that they just back off at that point. Sometimes they don't, and there's a load of things we can do if that's the case. Equally, the converse is true. So sometimes we represent clients, they get a letter from a competitor that owns the rights, and our clients in those situations don't want business risk. So they just stop, and the owner of the IP rights has effectively got what they wanted. They've excluded others, and they're able to do their business. Equally, sometimes we represent clients who really want to press ahead or don't think those rights are valid, in which case we can help them what we call invalidate the rights of others.
Now, I'm going to bring in an example that probably everybody knows here, Colin the Caterpillar. So for those people who are listening who don't know, there's a very famous cake, children's birthday cake. And I think there was quite a lot of litigation between various supermarkets, wasn't there, over who had the rights to this particular style of cake and naming. Other than that, I mean, have you got any examples that, anonymous obviously, where you can explain how things perhaps have looked pretty bad at the time, but have been resolved amicably?
So I think we work with some clients who have consumer good. They make consumer goods, and they are up against counterfeiters all the time, and we use a variety of different ways to prevent those counterfeiters from taking hold. It's an ongoing process because there's many of them, and we have a kind of an escalation process where we can start with a simple notification of registered rights, all the way up to potentially issuing proceedings, and we've managed to get sort of license agreements signed between the parties. So I think we have a number of different clients that, I say, take different approaches. Other clients will assess the IP that they may or may not infringe and come to a conclusion that, should it come down to it, they think they've got a strong case that they don't infringe or the IP isn't valid. And so we don't actually take any action, but we have assessed the situation and advised that, on balance, even if they were subject to infringement proceedings, they would win, or there is a likelihood of they would win. So I think each of our clients has a different, sort of situation to address, and so it's very important not just to have a one-size-fits-all approach to this.
One of the issues with Colin the Caterpillar, or indeed any other sort of, it tends to be Christmas time issue where one supermarket launches a product that gets as close as possible to looking and feeling like a product or service offered by another, without getting into trouble, is it can give people a false fear about these cases that come out into the public domain. For every Colin the Caterpillar issue, there's probably 1,000 issues that never break into the public domain as a story, and that's because long before they break out into the public domain, the matter settles, and that is an issue where law firms like Secerna, acting or representing the interests of one party, talk to other lawyers, and there is a settlement, an agreement that is reached on behalf of the two parties, usually two parties that are involved. And so these sort of quite famous cases that come out and sort of capture the public imagination, they're really the very tip of the iceberg. And the fact that these do come out can make people a bit fearful that you're going to end up in a huge scrap. But for every one of those huge scraps that do occur, the vast majority of issues either never become an issue. We represent clients that perhaps are thinking of launching a new product, they do a lot of what we call due diligence work. They look to see whether what they want to do would infringe somebody else's rights. And they exhaustively, in some instances, look and try and secure a position where they think they can proceed. But I can tell you that often we get to a point where the client just decides they don't want the headache of proceeding. And the owner of the rights never even hears about that, because the issue just is stopped in its tracks. So these intellectual property rights, whilst it's no guarantee that you won't find yourself in court one day, it's an unbelievably small amount of time. And these intellectual property rights act as a huge shield that means you never even hear from potential problems.
And just thinking about intellectual property as an asset again, I just wanted to ask, if it belongs to an individual within a firm, what happens when that person dies? Is it inheritable? Does it disappear with that person?
So typically, under UK law, any intellectual property that is generated as part of a business is owned by the company already. And so if they have generated that IP as an employee, it will automatically be owned by the employer. In terms of what happens when people pass away,
so the issue here is legal ownership and legal entity. So a human being is a legal entity, and a company is a legal entity, and a company and a person own rights in much the same way, actually. And a company can die just like a human being can die. And what one needs to have in place before a company dies, becomes insolvent and goes into administration, or before a person dies, needs to be carefully thought of, because there is a risk that if a company that legally owns rights goes into administration and legally ceases to exist, effectively dies, or if a human being that owns an intellectual property rights, if they physically die, unfortunately, if you've not taken steps to do something, the rights can automatically be transferred into the Crown, and it can prove impossible under those circumstances to recover those rights. So if a human being or a company does own at some stage some rights, some thought needs to be thought of as to what will happen with those rights, whether it's a will that clarifies what happens or whether it's part of the administration documentation. And we normally have some documents completed which we call an assignment document, which is a legal contract that transfers the ownership from one legal entity, a company or a person, to another before something bad happens.
Great. Well, on a lighter note, I just wondered before we finish whether you could provide our listeners with some top tips if they are a business and they think they need better protection. What do you think they should do?
Your top tips is having contracts in place before you start anything. It's always easier to go forward with the right framework than try to correct a framework afterwards. So consultancy agreements, make sure that if you're talking to anybody about intellectual property, you have a non-disclosure agreement in place, employment contracts, a director agreement when you set the company up, to make sure that any IP generated by directors is also owned by the company, and start to identify what you think you may have, and from that develop a strategy around it, and always keep that strategy in mind. Reevaluate regularly, make sure you're not going on the wrong track in terms of, have we protected things that we don't need? Have we not protected things which are actually key?
one thing that I guess I would say, probably the headline would be start to think about intellectual property matters sooner rather than later. Thinking about intellectual property and doing something about it, it isn't some sort of binary issue where you either do nothing or you end up spending a vast fortune and spend huge amounts of time. You can have a very gradual approach to it. And the sooner you start thinking about it and putting certain steps in place, the sooner you start winning. There's some really easy wins that an SME can attain. You know, having some basic contracts of employment that clarify some things, who owns what, having in place what we call non-disclosure agreements, having in place internally within a business an ethos or some well understood rules that intellectual property is important to the business, and that people should not feel just willy-nilly at liberty to tell all their friends and family about what's going on in the business. Most of these things cost virtually nothing, but they can really, really save a lot of heartache down the path. And then if in doubt, if decision makers are listening and they're thinking, I don't really know about intellectual property, it all sounds pretty tricky. Just go and learn a little bit about it. There's loads of online information. The governmental website's got some really good grammar courses on the basics. Go and talk to a patent attorney and have a short free consultation and really get the basics in your mind. And then as the business evolves, you can evolve your IP strategy with it as money and time becomes more accessible to you.
I'd say the final thing is we focus quite a lot on what a business can generate in terms of IP. The flip side, which we've mentioned, is what other IP might be out there that could stop you in your business. And at some point, you've got to try and identify that. And that's got to be at a suitable time. It can't be maybe too early when you haven't developed your product fully, you haven't finalized it. But if you do it too late, when you've maybe branded a product or you've got a warehouse full of stock available, if you do it then and you've spent all of that money, you could be stopped from selling a single product. So there is definitely a sensible time to start looking at what else might be out there that could stop or impact on what you want to do. And I think that can often be something that may be left a little bit late because it's potentially does incur cost, and it's something that can be perceived to be put on the back burner because you're focusing on getting your product ready. So I think that's definitely have an idea about when you want to do that sort of due diligence.
Thank you both. That's been really insightful, and thank you very much for coming along to talk to us today.
It's a pleasure.
Thank you.
If you've enjoyed today's episode, why not check out some of our previous conversations, including the importance of marketing with Paul Hart from Cargo Creative, and recently our live collaboration at Newcastle University, where we discussed the Arrow Innovation Project, helping small businesses connect with university expertise. Find all of these episodes and more wherever you find your podcasts. If you're a small business and you'd like to find out more about our leadership and development course, Help to Grow Management, please go to www.northumbria.ac.uk/help to grow.